During the past 3 decades, concerns about international terrorism have largely replaced concerns about communism as the greatest threat to American security. Congress has responded by enacting laws to combat terrorism, including one that makes it a crime for someone to knowingly provide material support to designated terrorist organizations. But what if someone only wants to offer humanitarian aid to such an organization, or to train it about peaceful means to resolve its disputes, without any intent to promote the organization's terrorist agenda? Does the Constitution prohibit criminal prosecution of such acts? The United States Supreme Court addressed this issue in Holder v. Humanitarian Law Project. The Humanitarian Law Project and others who wish to provide humanitarian assistance to, advocate for, or provide training about lawful activities to organizations designated as foreign terrorist organizations filed a lawsuit against the United States Attorney General and the Secretary of State and their agencies. Raising claims under the First Amendment and the Fifth Amendment's Due Process Clause, the plaintiffs sought an injunction against application of the Material Support Statute to their proposed activities. The Federal District Court granted their request for an injunction in part and denied it in part. The United States Court of Appeals for the Ninth Circuit affirmed the District Court's order. Both parties successfully petitioned the United States Supreme Court to review the case.